Next case set for argument is State of Ohio versus Dwaine Beaver. It's case number 18CA0055-M. The appellant's counsel has waived oral argument in this matter. That leaves the State of Ohio. Attorney Begluski, you will have 15 minutes. We've read the briefs, obviously, and are prepared to proceed if you are.
Yes, Your Honor. I wasn't aware that the appellant had waived, but
surprise.
I'm here now, so.
I think you called in this morning. He was having difficulties getting here, so
Okay.
we'll just hear from you this morning.
Well, good morning again, Your Honors. May it please the Court, I'm Vince Felucci, Medina County Prosecutor's Office for the appellee of the State of Ohio. I'll start with the first assignment of error. This is an ineffective assistance of counsel claim for failure to properly subpoena a witness, and the allegation is that Mr. Beaver's trial counsel did not properly issue a subpoena to a witness named Missy Holbrook because he didn't send her a witness fee check. Beaver states a bunch of things that are not in the record in his brief about Miss Holbrook being a nurse practitioner at Dayton Hospital, and says that she would have testified that the victim didn't tell her that Beaver said to keep the touching secret. Sort of an omission thing. She didn't mention anything to me about that. Now, none of that information about who Missy Holbrook was or how she might have testified, none of that is found in the record. So this court cannot consider it.
No proffer at all, or
No, Your Honor.
defense counsel?
No. All that's on the record is you see that there's a colloquy about the I subpoenaed this witness. They're not here. Can I get them here? And the judge says no, because did you send them a witness fee check because they're out of county? No, I didn't do that. Well, then you can't have them compelled to be here. And that was it. There was no discussion of anything she would have said or who she was. And again, even if this court were to accept those allegations about how she would have testified, which it can't, but even if you did, the victim herself testified at trial that Beaver told her to keep this touching secret. Another nurse practitioner at that same hospital, Dayton Hospital, Miss Thurman was her name. She testified that the victim told her that Beaver said to keep the touching secret. So the victim told another nurse practitioner at that same hospital. I don't know how many nurse practitioners there were interviewing her, but there's not a lot of context here. So one other person just saying, well, the victim didn't come up to me and say, he asked me to keep the touching secret. That's not terribly compelling, especially when the victim has been consistent from the very beginning and told numerous people this, came in here and testified at trial to that as well. Has been very consistent in that fact. So do we know, did Ms. Holbrook even ask the victim if Beaver said anything to her? We don't know. So there really isn't any context beyond that. So this court has held that the failure to subpoena a witness is not deficient for ineffective assistance purposes without a showing that the testimony of the witness would have assisted the defense. And as I said, that can't be done here because there's nothing on the record about how this witness would have assisted the defense. The second assignment of error has to do with the competency evaluation, the in-camera competency evaluation of this 5-year-old victim that was conducted. The allegation is that the inspection wasn't proper. In reality, the trial court here conducted a very thorough in-camera inspection of the victim here, found her to be remarkably proficient, competent for a 5-year-old, and I think you'll really see that come out in the record in this in-camera inspection. The victim correctly distinguished fact from fiction, described the difference between the truth and a lie, demonstrated that she knew she needed to be truthful, She also demonstrated a remarkable ability to recollect and talk about this incident where Beaver sexually assaulted her. I think you'll see that come out in the record as well. So she met all of the Frazier factors for competency.
Counsel, does the record reflect any concession by trial counsel as to the issue of competency? Did he at any point, and if so, how do we reach the merits of whether the court properly examined the child for competency?
I don't believe there was a concession as to competency in this case. This was, as I mentioned, just a 5-year-old. So, and obviously the presumption is if you're under 10. So there was certainly a question in this case, but I think she performed very well under the judge's questioning, and I think you'll see that come out. And I think he also is challenging the ultimate finding of competency also in this appeal. It's not just the method of the questioning. It is kind of thrown in there also in the assignment of error that they're challenging the fact that she was found competent. So they are challenging that in this appeal, which, as I said, I think when you look at the record, you'll see that she did hit all of these factors, and this victim was very competent. There's no rigid script that trial courts have to follow when it comes to questioning a child to determine competency. A trial court has discretion to ask exactly what questions how they're going to phrase it, these questions, as long as they ultimately get, as I said, the information that's relevant to those 5 Frazier considerations, which are all the things I just mentioned. And this is abuse of discretion, so the trial court did not abuse its discretion here. The third assignment of error is the sufficiency claim, and the claim there is sort of what Beaver's claim has always been in this case, which is that the state did not prove that sexual conduct occurred between himself and the victim. Like he did at trial, Beaver admits in his appellate brief, he admits to touching the outside of his granddaughter's vagina, but he claims that the touching was only to determine if the victim was wet, not for his sexual arousal or gratification. Of course, this court can look at the totality of the evidence and to determine what his purpose was in doing this. Was it for his purpose? Was it for his sexual arousal or gratification? There's a mountain of evidence that the state presented at trial to show that. The victim's mother testified that Beaver had no part in the victim's potty training, had never changed a diaper. He was a grandfather who lived far away across the state, would only see his granddaughter twice a year. So checking for being wet was not something Beaver had done or that he would ever do. The victim's mother also testified that at the time of the touching, the victim was potty trained and would only wet herself very rarely. So being wet was not even really an immediate concern for the victim's parents, let alone for it to be a concern for Beaver. The victim's mother additionally testified that the victim didn't have to be checked because when she would have an accident, the victim would immediately take care of it herself. She would change her own underwear, she would go to the bathroom herself. And then in a phone call with the victim's mother, shortly after the victim disclosed the abuse, Beaver admitted that he should not have done what he did. And also in terms of the touching itself, this was not just a momentary, instantaneous touch. And that was clarified with the victim several times after she disclosed and in the weeks after that. What the victim has said from the beginning and never wavered in that is that this was for about a minute that he was touching, at least. This was not incidental. This was not accidental. The victim said in no uncertain terms this was a pretty long touch. The victim testified that Beaver did not ask her for permission to check if she was wet. Didn't tell her that's what he was going to do before he touched her. This surprised her. On the day in question, on the day of the incident, Beaver didn't tell the victim's parents or anyone else that he checked the victim to see if she was wet. That only comes out quite a while later when the victim finally discloses the touching. Only then did Beaver come up with the I was checking her to see if she was wet claim.
Remind me of the scenario here. Was he babysitting her alone? Were the parents in the house?
The parents were in the house, Your Honor. They went down into Mr. Beaver's basement, and it was just the granddaughter, this victim,
In the basement.
and him in the basement together. He was showing her some, I think he had some worms or something that he was showing her.
Thank you.
Yeah.
We read a lot of briefs, so
Yeah.
that helps me out. Thank
Yes, and that's when this touching occurred. And also compelling was Beaver's odd behavior right in the moments before the victim disclosed his abuse. He was described, Mr. Beaver was described as nervous, clearly uncomfortable, even twitching. That also demonstrates consciousness of guilt. Finally, as I already mentioned, in conjunction with sort of the first assignment of error, immediately after Beaver touched the victim's vagina, Beaver said to the victim, "Let's just keep this between you and me, okay?" The victim has never wavered from the very beginning in saying that's what Beaver said to her right after the touching. She told multiple people this. She testified to this at trial. I believe even in the competency exam she brought it up. The fact that Beaver wanted to keep this touching secret is, of course, further compelling evidence of Beaver's sexual purpose here. Are there any
Is
other?
there any evidence that he was excited, aroused, or anything like that? That would show sexual gratification?
I think everything I just sort of mentioned is sufficient to show that. Did anybody actually say they saw him physically aroused? No, there was nothing like that. In this case, again, this was just the 5-year-old and Mr. Beaver down in the basement by themselves. I'm not even sure if a 5-year-old would know what that is or how to describe that necessarily, but again, there was a mountain of evidence showing, this was his purpose here. We can't get into somebody's head, obviously. We have to look at all the surrounding facts and circumstances.
The child was not examined, or was the child examined?
I believe, yes, the child was examined. There were no physical injuries or anything apparent, but that was to be expected given how long it was since that it had been since the incident. If there are no other questions, I would just ask respectfully this court to affirm the judgment of the trial court. Thank you.
All right, thank you very much for your argument this morning. The court will take the matter under advisement, issue a decision in due course. The clerk, of course, will mail you a copy of that decision on the day it's released. And as I noted, the Court of Ohio's website also posts the opinions. Looks like you're done for today.